Talking Supply Chain. In each episode, top supply chain industry professionals and the nation's top thought leaders join host Brian Strait and share their unique insights to help supply chain managers stay one step ahead of their competition. This is Talking Supply Chain.
On Tuesday, April 23rd, the Federal Trade Commission announced the final rule that will ban all non-compete clauses by American businesses. Hello, and welcome to this episode of Talking Supply Chain. I'm your host, Brian Strait, and today we are diving into the non-compete clauses with our guest, Stefan Meisner, a partner in the law firm Crowell Moring. Welcome, Stefan. It's great to have you with us today to talk about this.
Yeah, thanks. It's a real pleasure to be here.
Great. We'll get into some of the details in just a minute of the rule, but first let me set the stage a little bit for our audience who may or may not be familiar with what we're talking about here. Non-competes have been around for quite some time in business. The U.S. Government Accountability Office in May 2023 estimated that 18% of all U.S. workers are subject to a non-compete agreement, which means 20% of you listening to our podcast today probably have a non-compete agreement. They used to be very common with upper-level executives with key roles in companies, but in recent years, they've been used by a range of businesses, including fast food restaurants in some cases, that require their employees to sign non-compete clauses. The FTC estimates that banning them will increase worker earnings by an average of $524 per year and lead to the creation of 8,500 new startup companies per year. The agency's argument kind of boils down to this. Non-competes prevent freedom of worker movement and therefore holds down wages. And therefore, they think it's bad. The U.S. Chamber of Commerce has already said that it's going to sue to block the rule, which would go into effect 120 days from publication in the Federal Register. So as we get into this conversation with Stefan, I just want to say also that anything we discuss today should not be construed as legal advice. I'm sure Stefan would agree with this with me. If you have a situation that requires legal services, you should contact an attorney that can address your specific situation. So, Stefan, if we get started, let's get started with some of the latest developments as we sit and record this today. And that's the U.S. Chamber's efforts to block the rule. This is a legal process, so I don't know how you see this, but do you see this as a likely leading to a delay in the implementation of the rule as a likely outcome here, or what? How do you see their efforts here?
Well, thanks, Brian. And again, it's a real pleasure to be here speaking on your podcast. So yes, the U.S. Chamber of Commerce has filed a lawsuit in Texas, and another accounting firm has separately also filed a lawsuit seeking to stop the FTC from promulgating and enforcing this rule that's been issued. And as part of that, we should expect that these plaintiffs, the U.S. Chamber of Commerce and this accounting firm, have planned their litigation strategy. And an important part of that is going to be probably, almost certainly, seeking to stop the FTC almost immediately from implementing this rule. So there are legal processes that they can use as part of the litigation, things like a temporary restraining order or later a motion for preliminary injunction that the plaintiffs would ask the court, the judge, to issue an order that would stop the FTC from implementing the rule until the resolution ultimately of the lawsuits. And so, yes, I would certainly expect that these two plaintiffs would seek to do that in the very near term, which, if the court agrees, would stop the FTC from implementing this rule until the court ultimately rules on the merits of the case in the course of litigation.
Yeah, and this is a process that's probably going to drag out a little bit here, and at the very least, it may lead to a delay, at least until the process finishes here as well.
Yeah, that's 100% correct. I would expect this to be delayed substantially. So presently, as I think is the case, the FTC needs to publish this rule in the Federal Register, which triggers a 120-day period, after which, on the 120th day, the rule would go into effect ordinarily. This legal process is certainly going to intervene and delay that clock.
Yeah. Let's talk. We're going to get into some specifics in a little bit about for businesses and what they should be doing. But let's start with a little bit of history about non-competes. So, and why the FTC has done this. The belief among many is that companies have used non-compete agreements over the years to keep wages down for and preventing employees with specific skill sets or company knowledge from jumping to a competitor for more money. Workers on the other side of that equation obviously want to have that ability, right? Because one of the ways that you can get more money is to leverage either another job offer or just jump to another employer. So, can you talk for just a minute about why companies, kind of more broadly than that, and maybe even some specific examples if you have them, on why companies would typically utilize a non-compete agreement?
Yeah, sure. I mean, I think it's there might be particular things that are with respect to a particular business and a particular industry, but typically companies use these types of clauses, which are meant to prevent employees from moving to competitors for at least a limited period of time following the termination of employment, to protect their investments in employees.
Mm-hmm.
So often businesses engage in training and ongoing training, or things like that, which are certainly investments that businesses construe to be costly but important in terms of developing their workforces. So in effect, they want a benefit of that investment to, for employees to stay employed with them, for instance. It's also sometimes another justification that we frequently see is to basically protect the business. Many businesses have trade secrets or customers or basically proprietary things to the business that they're trying to protect from moving over to their competitors, for example.
Yeah.
And these types of non-compete agreements are meant to protect that, again, in some limited fashion. That's usually cabined by a period of time following termination of employment. But those really are the two main reasons. And there might be others that are very specific to the type of a business
Yeah.
that might involve a lot of collaboration between employees to develop things like strategies for finding customers, for example. And the businesses would want to protect and make sure that the people who are involved in that are committed to sticking with the business.
Yeah. I know, in supply chain, there are some areas in logistics, specifically the freight brokerage industry, specifically that these non-competes are very common. For freight brokers, who in many cases these people are just picking up phone calls trying to find a truck for a load that they have. And there are also in that industry there are some companies that are very aggressive about enforcing these agreements. So do you, when in your work on a day-to-day basis, do you deal with non-compete agreements a lot? Do you have a lot of knowledge on how often a non-compete agreement actually is enforced?
I mean, I do deal with them in my practice, and without getting into individual client
Right,
issues,
obviously.
right? Thank you for that. The companies have them, and they do enforce them.
Yeah,
So it's if a company believes that it needs to have a non-compete agreement, in my experience with the clients that I'm dealing with, they feel that's an important part of the relationship, an important part of preserving their business and continuing their business, and advancing the business interests. And they do enforce them to the extent they need to.
yeah. I know some companies use these to protect things like intellectual property, company secrets, et cetera, right? It's some of the things that you mentioned already. So I guess one confusion in my mind is, are we using non-compete clauses and agreements to supplement things that maybe a non-disclosure could do, for instance, right? So can you kind of address some of the similarities between what a non-disclosure agreement is and what a non-compete, and what some of the differences are and why you might use one versus the other?
Sure. So I think that obviously there are two separate tools that are apply in different ways, of course. So a non-disclosure agreement, or an agreement with a business or a person or a group of people, not to disclose certain identified information, that usually is something that has, for instance, a much longer period of time associated with it, but it is wrapped around a very a specific thing or an identifiable amount of information, let's say. And I think that in those instances, that does offer some protection for things like trade secrets or other types of know-how or things that we would call soft intellectual property. That's not a patent or a copyright. But those types of agreements are, I think, a little bit more limited in scope, let's say, than a non-compete agreement like this in terms of the breadth of the information that's governed here. Obviously, a non-compete clause, on the other hand, would prevent a person simply from going to a competitor. It doesn't really address competitive information or anything like that for a limited period of time. So again, these things are, cabined by like a year or 2 years or 6 months or whatever the term might be. And then the individual is free to do whatever they want to do. And it doesn't have there's no restrictions under a non-compete agreement with respect to any type of information or job skills or what have you that that person acquired while working for the employer. So they kind of address two different things. If I hope that's a little bit clear.
Yeah, and I think I've seen articles, I've seen stories, and I've heard firsthand accounts of non-disclosure agreements, leading to legal battles between companies because somebody just had a non-disclosure, and they might, and this has happened. I know this has happened in the autonomous vehicle space, right? An engineer jumps from one company to another, to a startup, and what that engineer's brain, if you will, was proprietary information to their previous employer versus what is just general knowledge that they know. And it leads to a lot of issues from that standpoint. Whereas I'm seeing this as a non-compete is much more cut and dry.
Yeah, it's a little bit simpler, and you don't have to get into like somebody's brain and figure out that difference, right? I mean,
Yeah,
I hope we never get the power to do that in reality, but that creates litigation, ambiguity in litigation, and businesses prefer to have, I think, a little bit more certainty,
yeah,
and I would imagine individuals do in some way, shape, or form too.
yeah. There may be situations where a non-compete agreement is the appropriate course of action for a business, and I think you've talked to a couple of those. But if this law goes into effect, it's going to effectively ban almost all such agreements going forward. There are a couple loopholes, and I'll get to that in a minute on there. But if we make the assumption that the law does go into effect, for a situation where a non-compete currently makes sense, do companies have options going forward, or are they just kind of out of luck?
Yeah, I mean, I think if this rule goes into effect, as you mentioned, there are a few very, very limited exceptions going forward to the rule. So
Yeah,
again, if it goes into effect, it means the rule is enforceable. That's what the whole subject of those litigations are that we discussed earlier today. There's a tremendous amount of risk to engage in those types of non-competes on a going forward basis once the rule goes into effect. And there really aren't very many options under the non-compete side. It's extremely limited. But what companies would still have are things like non-disclosure agreements, other types of policies on the protection of proprietary information.
hmm,
The companies would have to be a lot more careful and diligent about informing and making sure, first making sure that its employees understand that these protection of proprietary information is important to the company, that they acknowledge that there is proprietary information that they're learning, and that proprietary information may not be shared with anybody else. And that's, in terms of not hard intellectual property like patents or copyrights or things like that, those types of agreements, non disclosure agreements, and the protection policies and agreements around the protection of proprietary information, with employees are going to be the way that companies are going to have to focus their attention.
yeah. So this is going to be. I mean, this is probably great for law firms, right? There's going to be a lot of work here as companies try to figure out the path forward.
Well, I mean, of course, I think lawyers are going to be involved in advising their clients on the implications of this rule if it comes into effect eventually. And I mean, effectively, I think the advice is going to be around, best practices along the lines of protecting proprietary information, trade secrets, and things like that that I just discussed. But yes, I do see that, with a big change that this rule is bringing about, or purports or wants to bring about. There's definitely going to be some shift and need to take advice and figure out paths forward.
Yeah. So as I mentioned there, and you hinted at too, there are a couple loopholes. One of them is for senior executives. So according to the law, the rule, the FTC would ban all non-compete. So if you have one currently, it will go away, right, for current employees. But that is not true for senior executives. Those non-competes would remain in place going forward. So, two questions around this, if I could. The first is there any clarification on what is defined as a senior executive from the FTC standpoint? And secondly, well, actually, let me ask you the first part, then we'll get to the second one.
Yeah, that's probably best. So just looking at the rule, a senior executive is one or two of the following people type of person. So senior executive is defined under the rule to be a business entity's president, chief executive officer, or the equivalent. So if you're in that category, you're a senior executive. Or this is the second category, an officer of a company that has a policy making position, and meaning any individual who earns more than, and this is a crazy number, but I think it's funny, $151,164 annually or on an annualized basis, and has final authority to make controlling policy decisions on on significant aspects of a business. So the first group is pretty, I guess, pretty clear, but the second point is going to require, like, again, some thought.
Yeah.
More than $151,164 is a bright line, but the rest of it is going to be something that is going to be thought about.
Yeah. I think, yeah, I mean, that seems to be can be subjective, I think, in some ways, right? A company could say, yes, they have. I mean, what is controlling decisions, right? I mean, it's a, I guess some of this is stuff that has to be worked out as far as what exactly it's going to mean, and courts would weigh in as far as how these terms end up being defined. I would assume,
Yeah,
going forward, because a chief supply chain officer, they may have controlling decisions, but they answer to somebody else. So, do they really have controlling decision, or are they just executing somebody else's direction, for instance?
yeah, that's right. And I think that the FTC has also included a portion, a statement within this rule, so a portion of the rule that says, like, good faith efforts or a good faith belief that somebody is not subject to this rule. So I presume this is a situation that could apply, where if a company has an existing non-compete with somebody that they have a good faith belief fits within this definition of senior executive under the rule itself, that should be, okay, at least not, wouldn't subject them to some type of onerous government intervention. But the government may suggest that or state that, if this rule comes into effect, while you did have a good faith belief in that, you're wrong. And you have to remove that non-compete for that person.
Yeah. I can see a bunch of people making $145,000 right now getting raises in the next few weeks. Right.
Or certainly asking for them. That's pretty funny.
Yes. So the second part of that question related to these kind of loopholes is that for the businesses that do have these non-competes agreements in place that are going to be going away if the law goes into effect, right? I'm not talking the senior executives; we're talking everybody else. What are there options the businesses have at this point? Should they be looking at perhaps changing these people over to some other type of an agreement, or do they? I suppose they probably just have to look at what the role the person actually has as to whether they need to address them in their situation at that time.
Yeah, so it's kind of an interesting question, and I think that's obviously the choice of a business of itself, what it wishes to do. But as I suggested earlier, I think this rule is not going to go into effect for some period of time, if it ever
Yeah.
does. The litigants could be successful, the plaintiffs could be successful, for example. So I mean, I think it's one of those things. I would say be prepared
Mhm.
and consider what would happen once this rule eventually becomes effective. If it does, like what would that world potentially look like? And then I think that kind of would inform like the directions that businesses should go. But at the moment, I mean, even under if there were no lawsuits right now, it's I guess August would be when the earliest this rule could go into effect. Um, you know, there's maybe not a lot to do right now other than be prepared. So I do think these lawsuits are probably going to delay the implementation of this rule significantly. And until there's like a window where it looks as though this is going to become effective inevitably, I think being prepared and having some kind of idea of what to do at that moment, sometime in the future, would be what I would suggest is probably the most appropriate thing to do at the moment.
Yeah. So you kind of answered my next question a little bit there, anyway, which is kind of the what's next kind of approach question here. But so let me rephrase this just a little bit then.
Sure.
Um, for the companies, you kind of said be prepared and whatnot. Um, if the rule is allowed to go into effect, whether that's in August, that date, whatever that date in August ends up being, probably, or December or January, depending on when the legal process plays its way out, is 120 days enough time for a company to revisit this whole non-compete situation, or should they be working now perhaps to try to get possibilities as to where they may go? I mean, can they do it? Is 120 days enough time to implement new
Well,
processes?
yeah, I mean, I guess I'm sorry to say it depends, right? I mean, it could or it might not, depending upon how widespread these agreements or these clauses are utilized.
Yeah.
And again, that's sort of a company by company basis. But I think again, focusing on like what we might think of as protecting proprietary information or know-how or trade secrets or business strategies, things like this. If companies don't have policies in place at the moment that deal with those types of items, I would say you probably want to get thinking about that now.
Yeah.
But in terms of like, preparing for or altering the way in which you go about utilizing non-competes in the day-to-day operation of a business in terms of like hiring people who might be subject to them. I mean, you know, I think it's kind of wait and see maybe on something like that. But again, it would depend on individual business circumstances.
Yeah. Okay. Stefan, thank you. We're out of time. I do want to remind everybody in the audience again, I'm sure Stefan appreciates me doing this, but anything that was discussed today should not be considered legal advice. So don't take it as legal advice. If you're in need of legal advice, you should connect with an attorney that can address your specific situations. Stefan, thank you so much for jumping on and discussing the issue with me today. I suspect we're really just kind of at the beginning of this, and this is going to play out for a while. For our audience listening, though, they may have specific legal advice questions they have. How might they get in touch with you or somebody at Crowell Moring if they have some questions they want to need answers on?
Well, thanks very much. Again, it's a pleasure to be on this podcast. So thank you for the opportunity to address these issues. It's interesting and fun. You can find any of us at Crowell Moring at www.crowell.com. And happy to take questions or what have you after this podcast to the extent people have them.
Great, great. Um, Thank you. I want to thank my guest today, Stefan Meisner, and all of you that took time out of your day to listen to us. I greatly appreciate it. A new episode of Talking Supply Chain comes out each Thursday. You can find it on scmr.com or wherever you get your podcasts. So be sure to subscribe so you never miss an episode. Until next time, this is Brian Straight, and you've been listening to Talking Supply Chain.
Talking Supply Chain is produced by Supply Chain Management Review and Peerless Media. You can find it on scmr.com, supplychain247.com, iTunes, Google Podcasts, or wherever you find your podcasts. For more information on this topic or to sign up for our weekly newsletter, a print or a digital subscription to our publication, visit scmr.com. We hope you will join us for our next episode. For Supply Chain Management Review, I'm Brian Straight, and thank you for listening.